Hello. Good afternoon and a warm welcome to everyone. On behalf of THAKUR RAMNARAYAN College of Law, I, Devna David, would like to thank you all for joining us on our today's webinar, which is scheduled on Mergers and Acquisitions Law and Introduction. We really appreciate you all for taking out the time and being here with us today. I would like to introduce our guest speaker for the day, Mr. Kunal Kumbhat, sir. Mr. Kunal Kumbhat, sir, is an NLU Jodhpur 2006 dual gold medalist graduate with a 2007 LL.M Degree from the London School of Economics and Political Science. Sir is currently a partner at AZB and Partners Mumbai. And his practice areas include healthcare of life and sciences, mergers and acquisitions, joint ventures, general corporate, and private equity. Mr. Kunal Kumbhat, sir, has also been recognized as a notable practitioner for mergers and acquisition by IFLR 1000 from 2018 to 19. Sir, we are honored to have you with us today. Before we start, I would like to inform all the participants that this session is going to be an interactive session. We will be running a live question answer session at the end of the webinar. So all the attendees are requested to type down their doubts in the chat box. And also if the participants would want to switch on their videos, they can. But make sure while they're doing so and when they're going to speak, please unmute yourself and then please mute yourself back so that there isn't any disturbance caused throughout the entire session. And also kindly maintain the decorum. Feedback forms will be sent at the end of the webinar, so all the participants are requested to fill them in order to receive their e-certificates. E-certificates shall be issued within 15 working days. Now, we would love to hear from you, sir. The floor is all yours. Thank you.
All right. Hi. Good afternoon, everyone. And thank you, Davina, for the lovely introduction. And thank you, Ankush, for hosting this and running me through setting up WebEx. Good afternoon, everyone at TRCL, Principal Mr. A.K. Singh, sir, all management, all teachers, and of course, most importantly, all students of TRCL. Hello and welcome. I'm meeting you after approximately 3 months. Last I met you all was in person in March, around just before Holi. So it's probably 3 months to the date or something. And who knew that things would change completely in the last in the next couple of weeks since when we last met. And world today is actually a bit of a different place, and everybody talks about new normal and whatnot. And fact of the matter is that this is the new normal. So I'm here to talk to you on this new means and new mode which everybody has been doing. Ankush, could I request you that my video be sort of projected as the main screen? Right now, your video is what I'm seeing is my main screen. I'd rather see myself. It just makes things easier. Oh, okay. Perfect. Got it. All right. I understand. Got it now. Got it. So, of course, a part of this COVID, everything that is happening around here is also that people are having to interact like this. And me as a lawyer also, we've actually been doing deals, having video calls with clients, and actually life has moved on. Of course, M&A activity has slowed down a lot. But as I said, life has moved on. People are still working. And this is what they say, the new normal. So again, with that, I'd like to welcome everybody again and thank everyone for giving me this opportunity to speak to all of you. I would now like to straight jump into the topic, which is basically we are here to discuss the basics and an introduction of M&A law. And as Davina had mentioned earlier, we're going to try and keep this as a very interactive session. So I would encourage everybody to participate in the presentation, in the webinar, while we're talking, while we're discussing, and not necessarily reserve everything for right at the end. If you have questions, do unmute yourself and jump in and ask me. I would prefer that this webinar be conducted that way. And of course, I know a lot of you would be, with your videos off and probably snoozing. So I'm going to try and keep this again. I'm going to try and keep all of you awake because, I've also been a student myself. So been there, done that. And, I know how these things go on. And especially if you're not even here in person with me, it's not your fault. It is going to be difficult to keep focused. So I'll try and keep the presentation crisp and interactive. So please do jump in with questions and responses. So I'm going to be asking people questions. I would encourage you to ask me questions in the middle. And of course, at the end, we'll have a full Q&A session as well. So we just get into what, we start with what is M&A? Can anyone actually tell me what is M&A? Right. Radio silence, but that's fine. So look, what I'm going to do in this webinar today is first give you all the basics of what actually is M&A, then the rationale for M&A as to why is M&A done. I will follow that up with the types and modes of M&A and how M&A can be done, how it is practically done, and just give you some basics about the types, modes, various reasons, various structures. And finally, I will get into a little bit about the law as well and what the kind of skills that an M&A lawyer actually needs and what does a practitioner do as an M&A practitioner and so on. So that is the basic structure of this webinar. So starting off with what is M&A? So, M&A simply stands for mergers and acquisitions. And as the name itself suggests, mergers and acquisition. Mergers means two things merging into each other, becoming one, and acquisition is one thing acquiring another, taking over another. So that is, I simply put, that is what mergers and acquisition is. So, in slightly more legalistic terms, it is a way to acquire or participate, in an asset. That is what mergers and acquisition is all about. Okay. And of course, this is not just a regular asset that we're talking about. It's not, A person buying a scooter from B person or A person selling a cell phone to another. Generally, in business parlance, when we talk about M&A, mergers and acquisition, it is on a much larger scale where the asset is a company or a business. It's a much larger asset which we talk about, which is the subject matter in M&A law, in corporate finance related M&A transactions. It's basically on a much bigger scale, buying and selling an asset. Okay, so mergers and acquisitions and corporate restructurings, etc., are all a big part of the corporate finance world today. Now, what is the corporate finance world? Corporate finance world is essentially the whole universe, the whole gamut of corporates, companies, large entities being funded, arranging finance, giving finance, etc. So that is loosely a wide definition of the term corporate finance, and merger and acquisition activity is actually a big part of that. and what do you do in mergers and acquisitions? As I was mentioning earlier, the words itself hold the key. Merge, A merges into B, or A and B merge together, or acquisitions, A acquires B, and so on. So what do we do in mergers and acquisitions? You either bring companies together to form a larger company, or you split companies into smaller companies, or you spin off or carve out a particular business into another business, and so on. These are the various ways, these are the things that you actually do in mergers and acquisition laws. Okay. And of course, mergers and acquisitions are always in the news. I mean, chances are, if you pick up the Economic Times, the Financial Times today, one of the headlines will be about some merger or some acquisition, etc. M&A activity always makes headlines. Sometime back, Zomato acquired Uber Eats. Why did they do that? That was an acquisition, example of an acquisition. Big ticket headline grabbing. Why did they do that? Various foreign investors have been acquiring portions of Reliance Jio. I mean, last of that happened yesterday, and fortunately, my firm itself has been involved in that. Why is that happening? So, what is the rationale, or what is the reason for doing mergers and acquisitions? Can somebody tell me that? Can somebody give some basic points on why people do M&A, mergers and acquisition activity? Anybody? You could type up your questions also in the chat box and send it, and I can check that as well. So, okay, look, the basic and core principle behind merger and acquisition activity is that 1 plus 1 is equal to 3. 1 plus 1 is equal to 3 and not just 2. Okay, that is the basic principle of merger and acquisition activity. Like even in Hindi, there's a saying that ek aur ek 11. So that forms the core of M&A activity. And idea is to create shareholder value. Shareholders are the owners. They're the people who actually hold the asset. So to create value for them is why you do merger and acquisition activity. So two items, two things, two pieces, two companies put together, they are more valuable than those two assets separate, than those two companies separate. And that is the basic idea. Now, even in tough times, in tough economic markets and so on, bigger companies with more cash acquire smaller companies, etc. And that is all a part of M&A activity. So again, like I said, one of the main reasons is to create efficiencies, is to have more shareholder value. Okay, and there are various other reasons also why M&A activity is done. What you can do is it can be done to make yourself more competitive. It can be done to make yourself more efficient, operations more efficient. It can be done to acquire a greater market share. It can be done to create synergies, like A company does a certain activity and B company is a major supplier to that, and their work is so interlinked to each other that by being together and not being separate entities, they could actually create some sort of synergies, have more efficient operations. That could be a reason to do M&A activity. Cost reduction, again, efficiency and synergies can lead to cost reduction. So that can be a cause for M&A activity. Having economies for scale is another big reason for doing M&A activity. Acquiring new technology is, again, recently it's been a major reason for a lot of M&A activity. For example, companies like Google and Amazon, we keep hearing about them acquiring smaller tech companies across the globe. So, that is classic example of acquisitions, as to how acquisitions are used as a mode to acquire new technology, to buy new technology. Because while Google and Amazon, the likes of Google and Amazon, they will be doing their own research, developing their own technology. At times, it is the smaller companies which develop a niche piece of technology, and which is something which would be very useful for the likes of, say, a Google. The easiest way for them to get that technology is to actually acquire the company itself, which has developed that technology. Okay, so this is exactly why generally M&A is done. Okay, I mean, this, of course, there can be a lot of other rationales also. It could be for various tax reasons. One entity has tax losses, another one doesn't, so maybe trying to absorb those kind of losses. There are a myriad of reasons, but I've tried to give everyone a basic sort of overview on why it is done. I'll now get into what is M and what is A in the M&A. As I'd spoken right at the top, as the word suggests, M&A is mergers and acquisition. Merge is coming together, and A is acquire. So to put it in a slightly more legal, legalistic term, merger is when two companies actually come together, and either they both lose their past identities and they form a new company, or a entity is completely merged into another entity and it becomes a part of that, and the old entity, the old identity of that entity is lost. So A merges into B, and A and B together are now B, and the old A is lost. That is what a merger is, coming together completely. Acquisition is when A buys an asset B, and that acquisition could be by various means, by business, by acquiring shares, by acquiring assets, and so on, which I will get into the details a little later. Okay, so this is what essentially the M and the A of M&A is. Now, in business parlance, in business terms, there can be various types of mergers and acquisitions. Okay, now they could be horizontal. Now, horizontal merger and acquisition is when two companies are in the same line of business, they do the same products, they are in the same markets, and they are in direct competition with each other. And now, if these two companies come together, either by way of a merger or one of them acquires the other and so on, then that is a horizontal M&A. And this kind of M&A could be done for various reasons. For example, if both of them decide that, look, we are just competing with each other, but if we are together, we'll have a much bigger market share, and our operations could be more efficient, and we could reduce costs. Maybe we could reduce some people. So they come together and create a bigger, badder entity. That could be one of the reasons for a horizontal M&A activity. Another type of merger is something called a vertical merger and acquisition. What is a vertical merger and acquisition? When the two entities are quite linked to each other, they are not in direct competition with each other like horizontal, but they are vertically arranged. One is essentially supplying to another. Okay, so it could basically be a customer and a supplier. So one entity, let's say, is producing steel, and B entity is actually producing coal. Now, coal is an essential raw material for producing steel. So these are vertical, right? The steel entity is the customer, the coal entity is the supplier, and they are vertically organized. So these two actually could merge. And of course, classic reason for this is to create synergies and efficiencies. You produce the main raw material which I require for my product. Let's get together, let's be one, and make life easier for both of us. The third type of M&A, business driven M&A, could be something called a market extension M&A. Okay, now what is a market extension M&A? There are two entities which are in the same business, they do the same kind of products or services and so on, but they are not in direct competition, etc., with each other, because they both operate in different markets. Okay, now since they operate in both different markets, one of them or both of them may say that, let us expand our geographical reach or our market reach, or the kind of people that we reach out to, and therefore let's merge into each other, or let's one acquires the other and so on, so that your reach is increasing. Now, just by way of an example, let's say there is a taxi company in the UK, and there is a taxi company in India. Both are different, and the UK taxi company says that, okay, maybe I should have market presence in India also. They could have two options. One, they try and start fresh in India and start creating operations, etc. And that's going to be a long, drawn out process. They don't know the market so well. They have to create new entities, they have to create new assets, and so on. The other and possibly simpler way may be that, why don't we go and acquire that Indian taxi company? That way, our market extends. Now we are extended to the Indian market also, and we have presence there also, and we'll have a taxi business in India. So this is what a market extension M&A activity is. The next type of M&A activity is something called a product extension M&A activity. Yeah. Now, what this could be is that there are two companies which sell totally different products. Okay. But while they're different, these products are somewhat related to each other. Okay. So then you say, okay, you know what? Why don't we get together? And because our products are related, it will help. I mean, A company produces pencils, B company produces erasers. Now, while they're totally two different products, but they're quite related. So why not then get together? So then A and B decide to merge, or A decides to acquire B, or B decides to acquire A, depending on who has more cash, and they get together. Again, this is to create more efficiencies, create a better product outreach. Create something which will be easier for the customers. Also, you could actually do things like, okay, with one eraser, I will offer one pencil, etc. So you're making life easier for yourself. You're increasing sales for yourself. You're increasing customer satisfaction, and so on. This is something what is called a product extension M&A. And finally, the last type of business category of M&A that I would like to discuss is something called a conglomeration M&A. Now, here is when there is no common business, your products are not related at all. But let's say a entity wants to completely expand its area of business. Okay. And they're like, okay, we don't do this, we want to expand. So let's go ahead and do something. Uh, for example, Tata's today, they had no airline business at some point of time, and they were not related to the airline industry at all. And they decided, okay, you know what, we want to get into an airlines business, so let's go and acquire an airline. So that would be conglomeration. That's what Kingfisher did. Now, Kingfisher was not in the airline business at all, but Malia decided that, okay, I want to get into the airline business, so they went ahead and bought Deccan Airways. So they got into the airline business. Okay, I mean, these are just examples, but this is what conglomeration means, where one entity is already very big, is in various businesses, and wants to get a completely new business. So one, again, you could do it in two ways. Either you start from the bottom, start from the scratch, and build up that new business, or two, probably easier way would be, you see some good target, you see some good business, and say, okay, this is already set up. This is the kind of thing, this is the kind of asset I would like to have. So you purchase it. Okay. So all these are the five kinds of business type M&As that I discussed, right? So horizontal, vertical, market extension, product extension, and conglomeration. Okay. These are the business types of mergers and acquisitions. And how can you do all of them? You can do each of these either by acquiring or merging. Okay. Now, I've told you all the difference between the basic difference between an acquisition and a merger, and the basic slightly legal difference also. Now, I will take a step further and get into slightly more legalistic, though not very legalistic. I know it's a Saturday afternoon and I don't want to bore all of you to death. But a slightly more legalistic difference in and the type of modes in which these things can be done. Okay. What is an acquisition? Acquisition, in the corporate sort of finance world, where we are talking about companies and entities, and not individuals buying and selling small assets from each other. There, how do you acquire something? Acquisition can be by, you acquire the shares of a company itself, or you acquire the assets of that company which you like, or you acquire the business. All of this, of course, will have to be for cash. So this is acquisition. Whereas on the other hand, merger is where the consideration is shares. I will merge into you. I'm giving up my company, but in return, I will get your shares. Okay. So that, again, the slightly legalistic difference between merger and acquisition also is the kind of consideration. Okay. So acquisitions, as I said, can be done by various means. You could buy shares, you could buy assets, you could buy business. Mergers, again, can be done by various means. A merges into B, B merges into A and B merge together, A and B merge together to form a new entity, and so on. And I will get into the slight details of these a little ahead again in my presentation. But what the meat of the matter is that in mergers and acquisition, no size fits all. Okay. One size does not fit all. Every merger, every acquisition is different from each other. it depending on the requirements, the comforts, and various other factor of the parties, each merger and acquisition will have to be tailor made for those requirements and comforts. So mergers and acquisitions come in all shapes and sizes. Okay, there are different levels of complexity involved, different people involved, different structures involved. So merger and acquisition is not something which is cookie cutter, and you can say the way one has happened, the other will exactly happen that way. You could have two exactly same factual scenarios, or sort of two sets of different companies wanting to merge or acquire or whatever, but there'll always be slightly different fact patterns or different reasons. So the actual merger and acquisition activity in both those cases would almost certainly be different or slightly different from each other. You can't say that, oh, because A acquired B in that manner, exactly like that, I should also go ahead and C should also acquire D in exactly that manner. That will almost never happen. You can never put them in the same mold and expect the same result. So therefore, M&A activity will always be slightly different from each other. Now, this was generally the basics of what M&A is. Okay, I have two questions which I will get into very very shortly. I'll just get into that. Now, as I was saying, there are almost always different fact patterns and scenarios, etc. In various M&As. And again, every M&A is not successful. It's not as if, okay, you think, and in every case, 1 and 1 will not amount to 3. Okay, because that could be for a variety of reasons. It could be for a lack of foresight. It could be that the new management was not so involved as the old management was, or they were not able to build the same kind of relationships or maintain those old relationships. Maybe the global scenarios change. For example, nowadays, that's why M&A activity is low. Global scenarios, the finance, etc., is changing. So that could result in M&As failing. And we have numerous examples of M&As that have failed, and even Indian companies involved. For example, Tata and Chorus, that merger and acquisition, such a large scale merger and acquisition, unfortunately just didn't work out. Bharti Airtel, they acquired Zain Telecom in Africa from Kuwaiti sellers. That also unfortunately turned out to be a very bad investment and acquisition for Bharti Airtel. Some mergers and acquisition almost happened, but then didn't pan out at the last minute. For example, Flipkart and Snapdeal. Flipkart was going to acquire Snapdeal, and at the last minute, they had to break off the deal because of various valuation reasons and so on. So, Snapdeal, then a lot of their shareholders were not ready to accept the terms from Flipkart. So ultimately, then Snapdeal decided to cancel the acquisition and go ahead with creating something called Snapdeal 2.0. So, again, every merger and acquisition activity, like I said, is not going to be successful. So people have to, before you actually do some M&A activity, you have to be very sure that yes, you want to do it, and you need to have a proper plan in place that this is what I will do or I need to do to make my merger successful. Now, I'll get into the query. Priyal has asked me that it's not compulsory to give cash in an acquisition. And no, Priyal, you are right. In an acquisition, it is not compulsory to give cash. You could give, you could have a payment in kind, or you could have consideration in lieu of cash. So you could actually even give shares in lieu of cash in an acquisition. But see, let's be honest. I'm talking in slightly more practical terms. When A is acquiring B, mostly the chances are that the owners of B would want cash, etc. And generally and practically, and almost in all cases, when a full acquisition is happening, it would almost always be for cash. Okay. And of course, whereas in a merger in India, a merger in the strict sense is a court operated procedure, under the Companies Act, section 230 to 240, I believe, chapter 15. So there, of course, merger, schemes of amalgamation, etc. In that legal sense, there, of course, the kind of consideration you would be offering or be offered is shares, because A company is merging into B, or A and B are vanishing completely. So what do you get in return for your company would be shares of the new entity. And Priyal, do you want to come on or put your audio on and actually ask me the question? Or you mentioned there are 5 points for a merger, etc. Would you want to discuss those? Because I'm not sure what the complete question there is.
So,
Yeah,
hello.
Priyal. Hello.
Uh, so actually, I had read it somewhere that there are five conditions to be satisfied for a merger to be called a merger. If any of the condition is not satisfied, then it is called acquisition. So my doubt was that.
But what are those five sort of conditions are you're referring to? I'm sorry, because in the absence of that, I'm not
The
able to give you a
the
precise.
the first condition is that the assets of the transferor company should become the assets and liabilities of the transferee company.
Okay.
Then the second one was that at least 90% of the face value of equity shareholders should become the equity shareholders of transferee company. Then the point that you told that only equity share should be given as consideration. Then it is also said that no, the business should be carried on by the transferee company. Uh, there should not be closure of the business of the transferor company. And the fifth one was that it is related to books of accounts. So these are some of the conditions that are
Yeah.
to be fulfilled.
So look, broadly speaking, while these are the things that happen in a merger, and you're right. See what happens. Let me give you certain examples of what uh, a merger is. Actually, if hold on to that thought for 2 minutes, because I'm coming on to that. My next sort of my next part of the presentation is or of this webinar is actually the modes of mergers and acquisitions. So I will get into all these 5 points very shortly once I get into buyout and this kind of activity. Just if you give me a few minutes, I will get on to that. Meanwhile, I have
Okay.
another question from Maitri. Maitri is asked, how is M&A of banks different from M&A of companies?
Sir,
Yeah.
actually, we have a lot of questions coming from the viewers. So, do you mind answering it right now or after the session is over?
Okay, maybe you're right. If you're getting a lot of questions from the viewers, that's fine. You put them on the chat box, and let me. If I see something which is topical, for example, Priyal's questions were just literally linked to what I was about to talk. So yes, I will get on to those right now. The others I will answer at the end. Okay.
Okay, sir. Yeah, yeah. Thank you.
Okay. So now we've looked at generally, the basic broad reasons why M&A activity happens, the kind of, in the business parlance, what are the kind of mergers and acquisitions and so on, why some of them may not always be successful, and so on and so forth. Right. Now, and we've talked about very little legal reasons also, or certain legalistic differences, etc. Now I'm going to get a little more into detail of those. Okay. Now, mergers and acquisitions, like I said, one is merger, one is acquisition, etc. Now, take them together. The whole M&A the gamut, the world of M&A. In legalistic terms, it relates to two broad activities. Okay, broadly, one is a buyout, one is a joint venture. Okay, buyout is where you are merging, acquiring, etc. with the other. Joint venture is where you're partnering with the other entity. Okay. I will get into each one of them quickly. Now, what is a buyout? A buyout is when you are completely acquiring the other, or when you're completely together with the other. Could be a full merger, could be a full acquisition. Okay. How do you do a buyout? Buyout can be done in various ways. A company wants to acquire B. Okay. What it does is it buys all the shares of B from the shareholders of B. Okay, or let's say a majority of shares or whatever. So there you've done a buyout by means of acquiring shares. You could actually do a buyout by simply acquiring the assets. Let's say you don't want to acquire B, but B has a very nice piece of land and a building on it which you want to acquire. So you just literally cherry pick that asset and acquire that from B. I mean, let's say the main business of B is running that complex of buildings. So while you don't want to acquire the whole company because they may have certain other businesses which you don't like, or for whatever reason, maybe they have other liabilities which you don't want to be bothered about. So you decide, okay, this business is such, their main business is that set of buildings. So why don't I just acquire that asset itself? So that could be another way of doing a buyout. The third way is actually buying the business as a going concern. Now, what does, a business division as a going concern, what does that mean? Let's say a company is running taxis, and it's also running some buildings on lease, commercial buildings on lease. Okay, so it's got these 2-3 businesses going. You're a B company, you're a foreign acquirer, and you're a taxi company. So you are interested only in acquiring that taxi business of it. So you actually acquire just that taxi division, the taxi business division of ACE, all the assets and liabilities relating to that taxi business division. And how do you do that? That also, just that business acquisition, you could do that by means of a spin-off or a carve-out or an actual demerger. In a spin-off or a carve-out, what you do is you literally buy the assets in that taxi business, which I'm guessing would be all the taxis. You also get various contracts, etc., assigned to you and so on. And so that's how you could do a basic spin-off or a carve-out. Another way of doing it is you get all those assets, etc., transferred or demerged into a different, you get them transferred into a different company, and then you buy that new different company. That is another way of doing it. You transfer it to another company, or through a court process, you demerge it into a different company, and then you buy that company. So this is business. And then again, the last way, the legal way that I want to discuss of doing a full buyout is what we call the classic merger amalgamation. These are the terms which are used in the Companies Act also, and Chapter 15 of the Companies Act, Section 230 onwards. And these are basically court schemes. These are court governed schemes in which you do court governed schemes through which you actually merge. Now I will get into a little bit into what Priyal was mentioning, the 5 conditions, etc., and so on and so forth. So what happens in a merger? I mean, of course, in India, to do a full merger or an amalgamation, that is, 2 companies getting together with each other and one vanishing, etc., all that you have to go through the court. You can't do it privately. You have to go through the courts. But leave aside the courts for a minute. Let's understand the mechanics of what a merger is. Let's say there is a company. A company is held by its shareholders A1, A2, A3, and there is B company. B, and its shareholders are B1, B2, B3. Now, the merger could happen in several ways. One way could be that you apply to the court and A completely merges into B, okay, and the resulting entity is B itself. Okay, the B is the entity which continues, and A entity is now gone. And what happens to those shareholders A1, A2, and A3 of A entity? They get certain shares in the remaining entity, in B entity. They'll get certain shares in that. So then at the end of that merger, A entity is completely vanished. All the business, assets, liabilities, etc., all of A have now merged into B. Okay, that business is going on. And the shareholders of B entity now are not just B1, B2, B3, but also A1, A2, A3. Okay. So that is one way. Another way of doing a merger would be A entity and B entity are there. They apply to the courts. They have a scheme. And what they do is they totally merge into and form a new company called C. And after that, A and B completely vanish. Okay. Now, what would happen in that scenario is there were shareholders A1, A2, A3, B1, B2, B3. At the end of the merger, all of them, A1, A2, A3, B1, B2, B3, will become shareholders in C, and A and B would have gone. So both the businesses, all assets, liabilities, everything of A and B now have merged into a new entity, and that's how the merger is done. And now A and B don't exist at all, and they've vanished basically. And the court has now approved that everybody will be a shareholder in C. And of course, who gets how many shares, etc., is something which would depend on valuations and so on and so forth. Let's say if the valuation of A was very low and B is very high, and A is merging into B, then the number of shares that the old shareholders of A would get into B would obviously be lesser, and so on. I mean, those are all worked out mathematically and accounting wise, but that is the idea, that you value both separately, and then you figure out that in the merged entity, what would be the values of what business you have, or what the entity that you have sold or been a part of, that would govern what kind of shares, or what would be your share in that merged entity. So these are the ways in which one could do a buyout, as in it's a complete takeover, acquisition, etc. So you do it by shares, by assets, by doing a business transfer, or by doing an actual merger, demerger, etc. Another way, as I alluded to earlier, was a sort of a demerger. It's a spin-off. What you do is you go to a court, and you apply for a scheme whereby, let's say, a company runs 2-3 different businesses, business 1, business 2, business 3, and somebody is interested in buying a business. If I want to do it in a court approved manner, what I simply do is I want to sell off business 1. I demerge. I apply for a scheme whereby all assets, liabilities, my whole business 1 is transferred into a new entity. It is demerged into a new entity. And then the acquirer could actually, it could already be holding that new entity, or that new entity could be another subsidiary of mine, and I've transferred that business to that subsidiary, and then the acquirer acquires that subsidiary. That is another way, right? So this was one part of mergers and acquisition. Generally, legally, when we talk about mergers and acquisition, it's a buyout. The other sort of limb of it is something what we call joint ventures. Okay, in joint ventures, what happens is people come together, and two people hold the same asset in whatever ratio. It could be 50-50, it could be 75-25. 25-75, 51-49, 49-51, and so on. And that's how they carry the business. And why would one want to do a joint venture? Basically, because you feel that the other partner has something to bring on the table. Classic example earlier, when foreign investors, foreign entities wanted to come to India to start a business. Earlier, they wouldn't do it by means of a complete buyout, because look, they didn't have people on the ground. They didn't have specialization in India. They didn't know about Indian laws. I mean, even today, India is not a very easy place to do business in. So they always thought it's better to operate through a local partner. Okay, better to operate through a local partner, and then they would partner up with someone, create a JV, and then do business. Now, of course, times are changing now, and nowadays, even to a lot of our foreign investors, clients, we've been advising them to actually go for complete buyouts, or they are actually nowadays more interested in doing buyouts than JVs. And the reason is simple: most JVs have actually failed. It's very, very difficult for JVs to succeed. You really need good synergies, etc. And more often than not, not just India but even worldwide, we've seen JVs essentially fail. Think of it as it's basically like JVs like a marriage, whereas a buyout is basically being single. And if you're able to happily carry on your life single, I'm sure most people would prefer to carry on like that. In JVs, you need to keep a lot, in joint ventures, you need to keep a lot of factors in mind. You need to be sure about the partner, have a lot of confidence in that partner, be sure that it will be successful. It can be high risk. So the only reason why you would want to do it is that the joint venture partner can really, really bring something to the table and do it. Yeah. Now, I have, I see that there are a lot of questions now. Now, before I go ahead and talk about the role of a corporate lawyer or an M&A lawyer in M&A transaction, I think I'm just going to deal with some of these questions. So again, starting with Priyal, Priyal, we discussed how a merger will actually work, and you're right, those 5 points will work. Uh, what happens in an acquisition is I'm not really going to a court, and it's not a scheme. I'm just basically privately through a contract acquiring an asset or acquiring a shares or acquiring a business. So while in return, theoretically, I could give some other shares or something else in return, but mostly always practically, it will always be cash which I'm giving in return. Okay. Next question I see from Maitri is, how is M&A of banks different from M&A of companies? Now, again, I'm not entirely clear on this question. So whoever's asked this question, if they could throw some clarity on this. But look, banks are also companies, okay? So now, let's say when we are talking about the State Bank of India mergers and all those actually happen through court-approved schemes. Okay, so these various companies, State Bank of India, State Bank of Bikaner, State Bank of Hyderabad, and all these other smaller state banks, they actually merged into SBI, and they themselves stopped remaining to be. They stopped operating as separate entities through court-approved scheme. They all merged into SBI, and SBI was the entity that continued to operate. So, as I'd explained earlier, the shareholders of those banks, let's say State Bank of Hyderabad, State Bank of Bikaner and Jaipur, they would all then, after the merger, would have become shareholders in State Bank of India. So technically, a merger of a bank would operate exactly the same as a merger of companies, or even an acquisition of a bank or by a bank would operate just like any other company. The main difference is that you would have a lot of banking regulation, etc., that would come into play. So you'd have to look into the Banking Act and so on and so forth, because in mergers, there would be consents required from the RBI and so on for a merger of a bank or an acquisition of a bank. Whereas a company which is not in the banking sector may not require, obviously will not require consent from the banking regulator. If it's in a sector where there is no regulator or no regulatory consent is required, then those kind of consents would not be required. But in bank M&A, you would certainly need to involve the RBI, get consents, and so on. That would be a big difference. Now, next question from Prachiti is that who governs mergers and acquisition in India? Now, see, there is no central authority governing mergers and acquisitions, okay? However, there are various sectoral regulators and other regulators who look at merger and acquisition activity in certain scenarios. As I mentioned, for example, we spoke about merger of banks. So if two banks are merging or a bank is being acquired, certainly you would need the approval of the RBI, who's the regulator of banks in India. Let's say insurance companies are involved and M&A is involved. Beyond certain thresholds, if you're acquiring, say, more than 5% of an insurance company, you would need approval from the insurance regulator, which is the IRDA, right? Similarly, telecom companies, telecom regulators, okay? If it's a foreign acquirer, in India nowadays, most sectors, foreign acquirers can get 100% of a company without approval. But in certain scenarios, in certain sectors, say in defense, etc., you need, or banking, you can't just acquire 100% of that business in India without government approval. You could acquire maybe a part of it without government approval, but beyond that, you need the approval of the RBI or the relevant department. For example, in the pharmaceutical sector, you can acquire an existing pharmaceutical company, you can acquire 74% of that automatically, without going to any governmental authority or anyone. But if you want to acquire more than 74% of that, you would actually need the approval of the Department of Pharmaceuticals, Department of Health, and so on, right? So these are the kind of regulators who would be involved. They will not be involved in all kinds of M&A activity, but in certain M&A activity, you would have regulators involved. You would have this ties in with the next question from Maitri also on competition and so on. You, in certain scenarios, you may need approval of the Competition Commission of India. Not in all scenarios, but if your merger acquisition activity meets certain thresholds and is exceeding certain numbers. The next question is, if the merger is affecting the competition in India and a suit is filed beforehand, can it still be done? See, the point is, when you're before you do merger and acquisition, before you actually complete your merger and acquisition activity, you would have done your diligence. And what you would do is that if your merger and acquisition activity is meeting the thresholds that are provided under the Competition Act, before you complete your merger and acquisition activity, you would anyway approach the Competition Commission of India and get its approval. Now, if for some reason there of course have been instances where you're not meeting those thresholds and so you're not approaching the CCI, but other people have felt that this M&A activity is going against the spirit of the competition law and it can approach the CCI. Proceedings have been filed. Those things have happened in the past. So you can do it. I mean, people can file, well, not suits, but actually applications, etc., and complaints with the CCI. Now, after that, if the CCI feels it can actually stop your M&A activity, but if there is no court-driven court injunction or a CCI ruling on your M&A activity, nobody can stop your M&A activity. You will go on ahead with your M&A activity. But if somebody has filed an application to the CCI and the CCI has told you to stop it from doing your M&A activity till it completes an investigation, then obviously in that period you can't do your M&A activity. Next question is, what are the prerequisites for a successful merger between industries of developing and developed countries? And does it violate Competition Act with respect to India? I mean, look, there worth of investment. Hello. Okay, do you know at what stage this was interrupted? So I can just carry on from there again. Okay, so I'll just sort of recap it a little bit. I was talking about, we were talking about competition in India and, suit being filed before, and somebody had asked that question. So look, if you're meeting the thresholds and all, you will anyway approach the CCI. And if the CCI has approved it, then nobody can file something against it. If the CCI has approved your transaction, then you will go on ahead with your transaction. However, if you're not meeting certain thresholds, you don't need to approach the CCI. In the meanwhile, somebody can actually approach the CCI or a court to try and get an injunction. But till the time, or get an inquiry into your potential M&A activity. But till the time the court or the CCI doesn't direct you to stop or injunct you, nobody can stop you from actually doing that kind of M&A activity. Of course, let me clarify here. I'm talking in very generic terms here and not in exact sort of the strict, complete legal sense. I'm giving I'm giving more of examples and talking in with broad examples. We can get into the details, but I don't think this session requires that kind of detailing into competition law and so on and so forth. The next question was on prerequisites of a successful merger. Again, this is not it's not a cookie cutter. There is no set pattern or no set principles which will ensure that developing country industry and developed country industry they successfully merge. But it all depends on, after your M&A activity, how well you're able to synergize. Whether, let's say, a foreign acquirer has acquired a company in India, an Indian company, they've retained the earlier local partners for a few years to help with the business, how well they're able to integrate with them, if they are being cooperative or not. how well the local market is able to accept the foreign investor or the new avatar of the company, of the product, whether the general economic conditions continue to be the same and improve or not. All these are sort of factors which will go into determining whether the M&A has been successful or not between a developing country company and a developed country company, etc. And part of that question was, does it violate Competition Act with respect to India? See, look, like I said, if your M&A activity is meeting certain thresholds, then you need to approach the Competition Commission of India, and it's the Competition Commission of India which will then determine whether your potential M&A activity is violating the Competition Act or not. If it feels that it's not violating, if it's not stemming competition in any other way, if it's not creating any kind of monopoly, it will give its approval. If it thinks it is violating the act, or if it is doing something which is unfair, then it will possibly give you ways in which things you could do and then merge, maybe get rid of certain businesses and then do your acquisition activity, or it could completely say no to it at all. So it all depends on the Competition Commission of India. What would be dangerous is if you're doing a merger and acquisition activity and you meet those thresholds, but you don't approach the CCI at all. That would certainly be in breach of our act, and then you could be punished pretty severely for that. Now, next question is, can FDI be the reason for M&A and impact of new policy of FDI in India, which was announced in May 2020? So again, not entirely clear about this, but I'm going to take a step back and just clarify that in May 2020, it's not a new FDI policy which was introduced. Our FDI policy is the 2017 consolidated FDI policy, which has been going on. It's just that amendments are made to it by way of press notes. So in May 2020, a press note was introduced where they said that investments, all kinds of investments from originating from countries which share a land border with India would require government approval. Earlier, that kind of approval was only required from investments coming in from Bangladesh, Pakistan, and Nepal and so on. Now, of course, they've extended it to all countries which share a land border, and the reasons are obvious. We wanted to, have the government wants to have a say in investments that are coming from China. So that is the reason why this May 2020 press note came and that amended the FDI policy. Now, I'm not sure about the first part of the question, which says, can FDI be the reason for M&A and impact of, I'm not sure what is this FDI reason for M&A. Of course, I mean, so the person who sent that question, if you want, you can sort of unmute yourself and clarify. Okay, maybe the person is seeing this on YouTube, but essentially what I get from the question is that was M&A activity the reason for that amendment to our FDI that amendment to the FDI policy? Of course it was. The main reason for that was to try and control the M&A activity from China into India, basically. That's the official government reason, and that is why there was that change in the amendment to the FDI policy in May 2020. Next question, again, very generic. Why do most M&A fail? Look, again, there is no science, there is no exact science behind why M&As fail, etc. As I was mentioning earlier, M&As could fail for various reasons. It could be because the synergies that you were thinking did not actually fructify, or the kind of cost reductions that you were thinking did not fructify. Maybe the people who were good together before the M&A, after the activity actually happened, they didn't gel well so together. It could just be people. It could be economic conditions. For example, Bharti Airtel acquired Zen Telecom, initially pegged to be a very good M&A. Now, Zen Telecom had basically its assets were telecom assets in Africa. But then Africa, the economy really went down after that, and Zen became a really bad asset for Bharti Airtel. So that's why that M&A failed. It could be that, or Tata and Chorus M&A. Why that didn't pan out? Because Chorus just stopped doing well, and it became too expensive for Tata, which is something which they had not thought when they didn't expect it to be that to happen when they had actually acquired that. So, again, there's no sort of cookie cutter response to why M&As fail, but it could be for a variety of reasons, as I mentioned. It could simply be because of a lack of foresight. Next question is Vodafone taking over SR was a merger. I believe that was done by way of an acquisition of shares and not a core-driven merger. Now, what sort of acquisition was between Hamleys and Reliance? Now, Hamleys and Reliance, I don't think it was an acquisition. I think they have created some sort of a joint venture or a franchisee arrangement in India. I don't think it is an acquisition. I'm not entirely clear on the exact structure of that. I could have a look into that and maybe discuss with this person privately. And of course, even after this session, if all of you have queries and all, you could through your university send them to me by email, and I could get into all those one by one. Next question is what are the most important terms of purchase agreement in M&A deals? Now, look, this is quite a loaded question. I mean, we could spend hours and hours into this and still not be completely done with this response. I mean, I have spent last 16 years of my 13 to 14 years of my career doing these, and it's taken a whole career to figure out what are the most important terms of an SPA, a share purchase agreement, or a business purchase agreement in M&A deals. But to put it very shortly, I mean, and again, to give a very generic response, because I don't want to get into specifics of that, which would probably take me days and days. But look, what are you looking at? You need to define the asset very carefully. You need to be sure that the asset itself, the agreement needs to clarify that it does not have any encumbrances around that. You need to define the consideration very precisely. You need to have certain representations and warranties from the seller on that asset, that those need to be very clear. How, any actions that need to be completed before the asset is acquired, actions that need to be taken after the asset is required. Okay. Whether I will get some sort of protection if there's any defect in the asset. There should be no defect in the asset. That needs to be very clear in the agreement. These are the kind of terms which are very important and key in an M&A deal. What will be the tax treatment in that merger and acquisition, in that purchase? We need to be clear that who will be responsible for what tax and so on. These are the kind of things I would really broadly look at. I mean, there are a myriad of things I would look at, but I've just mentioned some of them from the top of my head. What is the difference between a joint venture and franchisee? Again, this is another question from Priyal. Now, look, joint venture and franchisee, good question. Let me give you an example, okay? McDonald's, okay? McDonald's in India operates or used to operate as a franchisee. What do I do in a franchisee? Today, me, say Kunal Kumbhat, I want to have a franchisee, okay? What I would do is that through a franchisee arrangement, okay, I would get certain license rights from McDonald's to use the name, etc., etc. They would tell me use these kind of products. They would give me know-how into how their burgers are made, etc. They would send people to train my people and so on and so forth. In India, I, as the local partner, would set up the restaurant, would get the real estate, set up the restaurant, hire the people, everything. I would use the branding which McDonald's has given me through my franchising agreement. Okay. I would be the one who would be responsible for local sourcing, etc., etc., everything. But McDonald's will help me with the branding, with the training, and to tell me exactly how the burgers are made and so on. And what do I give McDonald's in return? I would be giving McDonald's in return whatever franchise fee I've agreed with them and potentially a portion, a percentage of my revenues. Okay. But McDonald's itself does not own anything in my business. I am running my own business. The branding, etc., the franchise, it's a franchisee of McDonald's. So because they're giving me the branding, they're giving me the know-how, they're giving me the training, I'm paying them certain franchise fee and I'm paying them a certain portion of my revenues, a pre-agreed portion of my revenues. But that's it. The business is still my own. So that is a franchisee arrangement. Whereas if I were to do a joint venture with McDonald's, what I would do is we'll have a company and say it's a 50-50 JV. I would own 50% of that company, McDonald's India. McDonald's abroad, let's say McDonald's US or whatever, that corporation would own 50% of McDonald's India. Okay. And then we would run that together. So I'm not going to be paying, no one is paying anyone any franchise fee or anything. They bring what they have to the table in that joint venture. Me as a local partner, what I would probably bring to the table is local expertise. I would arrange for real estate. I would arrange for offices, restaurants, people, and all that. That would be my contribution, and maybe financing also, financing of that. McDonald's contribution to that would be, they'd be giving me know-how. They would allow me the use of their trademarks, their branding, etc. They bring that to the table. We put all that together. We are 50-50 into it, and we run the company. After that, whatever profits there are, whatever losses there are, we would be sharing them 50-50. Whereas in a franchisee, even if there were losses, McDonald's would still get its basic franchise fee and a part of those revenues. That would be the main difference between a JV and a franchise. Now, next question is, let's say a company overpays for another company. What typically happens afterwards, and can you give any recent examples? Again, I'm not, if the person who sent this question could sort of unmute themselves and discuss the question, it may be a little easier.
So the questions are coming on the YouTube, so that's not really possible for them to like unmute the mic and ask you again.
Okay.
Revise the question.
Okay. Understood. That's fine. Look, let me answer this with whatever understanding I have of the question. Overpays meaning you basically, once you, let's say you've bought a company and you realize that, oh, I paid 100 for this, but this company is worth only 50. Look, you can't really do much about that, okay? Unless you hide some unless you hide some sort of indemnities, etc., or unless you overpaid because of some fraud or for that kind of reason, then of course you would have various avenues open to you contractually and maybe criminally or legally, otherwise to approach the courts and all. But in the absence of that, if with your eyes open after all your diligence and everything, if you overpaid for an asset, there's not really much you can do about it. Recent examples, I can't give you absolute recent examples of A overpaying for B, but Kingfisher certainly overpaid for Deccan Airlines, and they ultimately suffered. They paid a huge price for it, and they suffered. I mean, one of the main reasons for Kingfisher coming down completely was because they overpaid for Deccan Airlines. Okay. Next question is from AK Singh sir only. JVs in fact temporary marriage gets dissolved after a flux of time or completion of venture. Yeah, I mean, look, JVs, I don't think I've ever seen a JV which is gone on forever perpetually. JVs, even foreign JVs in India, foreign and Indian JVs, etc. After a certain point of time, initially all of them were there because Indian laws did not permit foreign investors to be fully and completely involved or fully own an asset in India. You always needed by law or by our foreign investment laws, you needed some Indian partner. But then even those kind of laws relaxed over a period of time, and then the foreign investors decided to go the whole hog on their own. So then either they bought out their Indian partners because the main purpose of that JV was because of Indian law. And once Indian law changed, they decided to dissolve that JV or acquire it fully. Certain JVs by the nature itself are such that once that venture is over, you will need to get rid of it. For example, if you have some kind of an R&D or scientific JV where the purpose is to develop a certain kind of product and that's it. So once that product is developed, you would get rid of the JV. So you're right. So you're absolutely right. It is a kind of a temporary marriage that gets dissolved after a certain flux of time. The only thing is, what I would like to say here is whether that dissolution of marriage, of that JV marriage, is for a good cause or a bad cause. I mean, more often than not, we've seen JVs being dissolved badly, which no one would want. Everyone would want that dissolution happens nicely and in a peaceful manner when the actual venture that you sought out for or which you started with is fully complete, or you both, or let's say foreign investor, Indian investor, a foreign investor wants to buy out the Indian investor, both get onto the table together and nicely decide to part ways. So no one would want to part ways badly. You'd want to do it nicely. Next question.
Sorry to interrupt you, sir.
Yeah.
So we are getting a lot of questions. So I'd request you to complete your session and then answer those questions, because they are never ending and the session won't be.
Absolutely. No, so I think, the good thing is through these questions, we have actually managed to discuss a lot of, my presentation itself. So that's a good thing. So I'll try and quickly get through the rest of my presentation, of the webinar, which now focuses on the kind of skills which an M&A lawyer has. So, again, I'm not going to now fully get into JVs and buyouts and so on. I'll generally discuss what do you do, or what does a lawyer do, or what a lawyer looks at when they're looking at M&A activity. Okay. And I'll just take an example of a basic buyout. Let's say a foreign investor acquiring an Indian company, an Indian asset. You would, of course, start to look, your first port of call would be to look at the foreign investment laws, whether that kind of acquisition is allowed, not allowed, whether that sector it is allowed or not, how much you can acquire, do you need government approvals. You would then look at the contracts, licenses, etc. of that company, whether you need approvals from any other regulator or a third party and so on. And of course, most importantly, you would look at whether the person who's selling you that asset or those shares actually owns those shares or not, whether there are any encumbrances around that asset or not. Those are kinds of things you would look at. You would also need to consider commercially and business wise that once I acquire this business or asset, will the business continue to be there? Will there be business continuity or not? Before I acquired this asset, let's say Indian promoters and owners in India, they have a lot of related party transactions. I run a business, so I would really know the people well, or maybe they'd be my relatives only who would be supplying to my business and so on. So all the supply chains, the distribution chain, everything is nicely set up. So I would need to make sure that once I acquire that asset, I get the same or similar kind of access to those supply chains, distribution chains, and so on. If let's say I'm buying a steel plant, but I need to be sure that, the coal, the limestone, etc., that is required for my steel plant, I will continue to have access to that once I acquire my steel plant. I don't want to be in a position where I've acquired the asset and then I get to know I can't run it properly. That would be a classic reason why my acquisition would have failed fully. Okay. So, even as a lawyer, when you are preparing for this M&A activity for your client, when you're diligencing, you would need to think commercially. So, of course, you would need to look at their legal contracts and licenses and their corporate structure and so on. But you would also need to think commercially and advise the client where you think that the client should be thinking commercially or business-wise. So while you may not be taking those decisions at all, but your role would be to guide the clients into those commercial aspects or those business aspects. Legally, you would be looking at the title of the asset or the title of the shares, etc. Those are the legal aspects that you would be looking into. But what you also, the value add that a good M&A lawyer will bring for his client is if he can guide his client a little bit, not much, because it's not your job fully to be involved in commercial or business aspects, but if you can guide your client a little bit into those aspects. For example, if you think that there are certain key personnel who are working in this company and who you would want to ensure that they continue working into this company after I acquire it, then you may want to guide that client that, look, when you're finishing the transaction, one of the conditions should be that on the day this transaction completes, those key employees also enter into fresh contracts with the company, assuring the company that they will continue, say, for the next 5 years at least. Okay. Or if you think that the people, the sellers, the promoters who are selling you this business, if you think they are still very key to this business and you need their help in transitioning their business from them to you, then maybe entering into contracts with them to ensure that they continue to be employed, or they become advisors to the company, or consultants, or employees, or whatever, and they guide the company through the next 2, 3, 4 years to transition it when you are the owner. So what happens is that, therefore, as an M&A lawyer, not only do you need to know your basic companies law, corporate law, etc., but you also need to be aware of various other laws, the basics of employment law, finance law, competition law, which I was mentioning earlier, which I discussed. So you need to know bits and bobs of everything. So what I'm trying to get at is that as an M&A lawyer, you're not just a specialist in one law, but you need to be a jack of all trades. Okay. You could very well be a specialist M&A lawyer in one sector, say, okay. Or you could be a infrastructure specialist M&A lawyer, or a telecom specialist M&A lawyer. That could well be the case. But at the same time, you would still need to know various aspects of different other laws, employment law, labor laws, environment law, little bits and bobs of that. You will always need to know to be an effective M&A lawyer. I'll tell you some of the reasons for that. Now, right when we start any M&A transaction, one of the first steps that is done is something called a due diligence. Shortly put, a DD. I'm sure some of you who intern law firms or who have lawyer friends, corporate lawyer friends, you would have heard the term DDs. DD is actually the first step of any M&A activity. And what is a diligence? A diligence is basically, it's like a legal audit. It's like a legal investigation into your target asset, the company that you want to acquire. And let's say, for example, if you're acquiring a company, as a lawyer, you would be looking at various aspects of that company. And I'll just give you certain examples. You'd be looking at the corporate aspects of that company, the company's law related aspects, whether the shares are duly issued or not, whether they've been holding their meetings in time, who are their directors, have they been appointed properly or not, and so on and so forth. Okay. You would be looking into the financing aspects of that company. What are the kind of loans it has? What are the kind of assets of that company which have been given a security for those loans? Do we need consents from the lenders to do our M&A activity? You would be looking at their contracts. Contracts could be vendor contracts, supplier contracts, IT contracts, and so on, a myriad of contracts. Do you need any consents from any party to do your acquisition activity if you acquire that company? Because there's going to be a change in control of that company. Can any of the major counterparties to a contract simply terminate their contract if I do, if there's a change in control, or if I acquire this company? I'm about to acquire a company which totally depends on, let's say, XYZ supplier. If that XYZ supplier does not supply this product to me, this company would become useless. Okay. I acquire this company and tomorrow XYZ completely terminates the contract. Then my acquisition would be useless. So I would need to be very careful that, does the contract with XYZ require a consent from XYZ to do a change in control? If XYZ says, no, I don't want, if you acquire that company, I'll terminate the contract, I will not supply you this, then you will not want to go ahead and do the deal. So you will want to inform your client that, look, before you do this deal, XYZ is the main supplier. Please get a consent from him. Or even if a consent is not required, commercially, you should have a side discussion with XYZ, get into a meeting with him and understand from him that whether he will continue or not once you take over the company, once you acquired the company. You will want to look into the various licenses, permits, etc. of that company to ensure that they will continue once you've acquired, or to check whether any consent will be required from a government authority or a third party. You will look into their employment aspects, HR, labor aspects of the company. If the company is involved in manufacturing or various other things, then environmental aspects, insurance of the company, whether its insurance is in place or not, if anything is expiring, whether it has appropriate insurance. You will look into the litigation of that company, whether that company is involved in any major litigation or not. You will be advising the company on that. You will look into the real estate, the properties owned or leased by that company. Okay, so these are all some of the things that you will be looking into a company at the start of the M&A activity for your client. This will be a part of the diligence activity itself. And of course, separately, there would be tax diligence going on, financial diligence going on, business diligence going on. Those would be carried on by the relevant specialist. But as a lawyer, you'd be looking into the legal due diligence and would be looking into all the kind of things that I just mentioned. And this DD, as boring and mundane as it sounds, but this actually forms a core of the M&A activity, forms a very important part of it, and it could actually determine the structure itself by which you will do your transaction. For example, initially your client had thought that, yeah, I'm going to buy this company itself fully. But then through your diligence, etc., you figure out, buying the company may not make sense. There are too many liabilities attached to it. There are too many labor issues going on. Maybe there are too many court cases going on. And with your client, you figure that, oh, look, actually, the only reason I wanted to buy this company was because, it has this asset which I want to buy, or it owns this software which I want to buy. That's the reason why I want to buy this company. So then you may decide that, oh, why buy this company? Why buy this whole company? Let's just do an asset transaction and acquire just that one asset or that business division. So your diligence could actually, govern and help your client figure out what should be the structure of the kind of transaction. Now, once you've done your diligence, etc., you actually get into the documentation and transaction for the M&A activity and the negotiation. So then, as an M&A lawyer, your drafting skills need to be good, and your negotiation skills also need to be good. So, along with basic knowledge of various laws that I mentioned, of course, you need to be solid at your company law, corporate law, as well as your foreign investment laws, because most M&A activity is foreign investor driven. Of course, there is a lot of it which is domestic, and domestic there you don't need, their foreign law is not involved. But most corporate law firms, a lot of the M&A activity they do is foreign investment involved. So you need to be very good with your foreign investment laws. Now, if you are involved in M&A activities of public listed companies, then you would need to be well aware of, SEBI related laws. Okay. If you're a specialist in, say, banking related M&A or insurance related M&A, you would need to know banking regulation well or insurance regulation well. So of course, these are specialists. So all these are the kind of laws as a corporate lawyer you would need to know. And at the same time, you would have to have basic knowledge of, say, employment laws, environment laws, little bit about tax. Of course, not be a tax specialist, but have basics and know what kind of withholding taxes there may be if shares are being sold or bought and so on. Have basic knowledge of various licenses, etc., laws in the various kind of sectors that operate. Have basic knowledge about Competition Act, because that is very important. You should at least know the thresholds. So straight away, at least at the outset, you should be able to gauge and tell the client that whether an approval from the Competition Commission would be required or not. And then, of course, you can leave it to the specialist competition lawyers to actually help the client with that approval, application, and etc. to the CCI. But at the outset, you should be able to give the client a very broad idea that, if you're hitting these kind of numbers, then you may need to approach and get approval of the CCI. Okay. And so ultimately what I want to conclude by saying is that as an M&A lawyer, you need to be a bit of a jack of all trades, and as I said, you could specialize in one sort of M&A, technology, banking, insurance, etc. But you would still need to know certain aspects of various laws. So I think these are the key skills which an M&A lawyer needs to have on the sort of legal negotiation, research, and drafting aspects. Finally, along with that, what you also need to have is very good organizational skills. Okay. Particularly if you're doing large M&A transactions, you will have a lot of moving pieces. Okay. So to ensure that everything is coming on time, all the documentation is there, whatever is required, whatever the conditions in your documentation are, those are met. Every separate party is sending or receiving things which it is supposed to. Organizing all that. Organizing an M&A transaction, particularly a larger one. You could have many parties involved in an M&A transaction. So even organizing that all their signatures are coming on time, everything is being exchanged, that can be a massive sort of organizational exercise. Okay, just a project management exercise. So not only do you have to have various legal and drafting and negotiation skills, but I think it is key to have good project management skills as an M&A lawyer. Because once the document is drafted, all done, everything is done, that's why all your legal drafting and negotiation skills are done. To actually close and complete the transaction, to do that, you don't need to be a lawyer, but you need to be a good project manager. You may be managing various other lawyers in various jurisdictions. You could be doing an M&A activity which involves 30 jurisdictions. So coordinating between all those. So again, project management, I think that is a key skill which you should have, and which of course in the course of your career as an M&A lawyer, you will develop. So to develop that, the basics one should have, and which one can develop right from their school days, college days, etc., is to be organized. Those basic organizational skills you should work at. Because if you are too haphazard, you will never be able to close an M&A deal properly. You will always have issues at the last minute. Suddenly you will realize, oh, I needed this document also to close this transaction. And last minute, now how do I organize it? Oh, this party forgot to send its signature. And now you're realizing it when you're about to close the deal. Whereas if you were organized, you would have slotted things in place and figured out that, yes, I have received A, B, C, D, tick mark, E is missing. Well before closure date, you actually organized to get all that. So this is a softer, non-legal skill which one needs to have as a good M&A lawyer. I think that is about it on my presentation. And if nothing else, I'll just quickly try and plow on with the rest of the 4 or 5 other queries that are there. Maitri, anything?
No, sir. The 4 questions there are more 4 questions I've already written in the chat box. You answer them, and other important questions will be mailed to the placement email ID. So then we'll mail it to you, and then you answer.
Sure, I think that is good. I think so next question is how the goodwill is valued in case of M&A after merger and acquisition, and how consideration is decided. I'll take a step back now. Valuation exercise for an M&A is a major part of M&A exercise, because valuation is what will determine the consideration, and valuation is something that will be carried on by the financial advisors or by accounting terms and so on. Now, of course, lawyers are not going to be involved in actually figuring out that consideration and valuation. The bankers or the accountants or the financial advisors will be involved, and they will they could use various means to determine, or various techniques to determine that kind of valuation. Various valuation models could be used. They could use DCF valuation model. They could use multiple model. They could use a market comparative model. Okay, a net asset model they could use to do the valuation. So various models could be used, and it would depend on the parties. They will, of course, then sit across the table and finally come together on a value. They could use a combination of various methodologies, valuation methodologies, to arrive at a valuation. And basis that valuation, a consideration will be decided. It may well be that, basis valuation is 100, but I could be very desperate to actually buy that asset, and I would be willing to pay 200 for that. And that is simply because I see a lot more potential in that. Now, how is goodwill valued? Look, I am not an accounting specialist or a financial specialist, but goodwill calculation, valuing the goodwill would be the job of the accountants and the financial advisors. In case after the M&A is completed, I mean, again, this would totally depend on how you're preparing your accounts, and of course, technically, your goodwill of the acquired entity should add up into the existing goodwill of the acquirer entity. Now, whether that 1 and 1 will add up to 3 or not would depend on the accountants and the auditors and the treatment there. So that is something I can't go into details about because I'm not a specialist in that. But happy for you to try and introduce you to some accountants or financial specialists who could help you with that query. Next question is it going to be any changes to the Indian companies merged with China companies in current situation? Look, the companies where there is Chinese investment already, those can go on as usual. But currently under the law, those companies also can't receive further investment from China without governmental approval. That is the current law as it stands. We understand that there may be certain changes to it in the near future, let's say in the coming few weeks or coming few months. Government, a lot of representations have been made, and government is planning to come out with certain clarifications on that May press note that it came out with. which provided that governmental approval will be required for Chinese investments. It may well be the case that government may clarify that, look, if you're already an investor, if a Chinese investor is already an investor in an Indian company, then, and if that company is doing a rights issue or a bonus issue, then you don't need governmental approval. So just basically to further capitalize your company, you don't need approval. But if you want to increase your percentage stake in that Indian company, then you may need governmental approval. That may well be the case. That nothing of that sort is coming right now, but I do understand various representations are going to the government to at least permit that, because otherwise companies will have a lot of difficulties, the companies which already have Chinese investments. But again, don't take my word for it. Let's wait and see. We're also waiting and watching. Our clients are asking us similar questions, and our response to them is simply that we need to wait and watch when government comes out with its clarifications in this regard. Next question is, does dumping foreign products in domestic market impact or violate competition commission like Chinese products in India? How can we correlate economic problem with competition? Look, this is a very wide question. I mean, this is going from economics to customs laws to competition laws and so on, as well as basic economic models and all. But I'm going to try and answer it very shortly and simply in sort of layman and slight legalistic terms as well. Look, dumping of products, simply put, is not allowed. That's why we have our customs laws and competition laws in place. Okay. If you are able to, however, if without defeating your customs laws, okay, if you're able to supply products to India, then nobody can stop that. Now, what we call dumping of products, the basic issue in India now is that we are not manufacturing something on our own. If I need to buy a phone, if I am not manufacturing phones in India, or if the phones being manufactured in India are not of good quality, automatically I will have to import phones from China or wherever they are being manufactured. Now, China is the manufacturing hub of the world. So the issue is that as of today, some of the best products are manufactured in China, and not just India, but all countries in the world are reliant on that. Now, if Chinese companies are dumping products in India by violating our competition or our customs laws, then of course that is something that is actionable. But if they are not, then Indian customers also have no choice but to rely on that. So what does India do in that scenario? We need to develop our manufacturing abilities and facilities such that we can compete with those Chinese manufacturing abilities, and not just create manufacturing facilities in India, but create manufacturing facilities of quality, who can produce the kind of quality that is being produced there. Produce, say, an iPhone, manufacture an iPhone in China, so that iPhone moves its manufacturing facilities from China to India. We need to build that kind of ability. Now, whether Chinese acquisitions in India, apart from the fact that right now they require approval from the government, from a competition commission perspective, they would need to look at thresholds, and if those acquirer entity or the target entity, if it meets certain thresholds, then you will move the competition commission for approval. Then that is all fact-based scenario. A mere fact that a person wants to acquire a B asset in India, that in itself, we cannot say that, oh, this violates competition laws in India. It would be fact-based. It would have to be figured out on a case-by-case basis, and on that basis, you would need to approach the authorities in India. But if it is found out that you were meeting certain thresholds and you were supposed to approach the government authority, the CCI, Competition Commission of India, and if you did not approach it, then that is a direct violation of Indian laws. So again, this question is extremely broad. If the person who sent it, if the person was here online, we could have narrowed this question down or discussed it in more detail. But in the absence of that, it's difficult for me to give further details or further response on this. Last part, one question is, how does reverse merger work? Is it good for new companies? Look, reverse merger, one can't say if reverse merger in totality is a good concept or a bad concept for new companies. It would depend case by case. Now, let me explain what a reverse merger is. Reverse merger is also called a demerger. Okay, and this is something that I discussed initially when I was discussing how one could acquire an asset. Let's say I have company A. Okay, now my company A has various businesses or various assets. Those are asset B, asset C, asset D. Okay, and there is an acquirer Z. Z wants to acquire only asset B of mine. Okay, so what I could do is I could segregate that asset B of mine by means of a reverse merger or a demerger. What I would do is through a court approved scheme, a new company would be set up. Okay, let's say company Newco. Newco could be set up by me only by company A as my wholly owned subsidiary, and by a court approved merger, a demerger, what we call a reverse merger, we would segregate that asset B into company Newco. So shareholder A is still holding all of Newco, and then the acquirer Z acquires that company. Okay, by paying cash consideration to, by paying cash for the shares of company Newco to the shareholders of A, who are also the shareholders of B, of Newco. The other way is that the acquirer Z, he has created Newco. Okay, by means of a reverse merger, that asset B is moved to Newco, and in consideration, now the shareholders of A, they are not going to get cash, but they are going to get shares of that Newco. A itself, rather, the company A, it has given its asset B to company Newco. So in return for that asset, the consideration that is paid to company A is shares of Newco. So that is how, those are the two ways in which somebody does an acquisition through a reverse merger. Last question is, what should be the first step to synchronize companies post merger? I mean, again, look, this is an extremely broad question, but I'll try and answer it very shortly and succinctly. Look, there is no set response to this. Post merger, you have to take many, many, many steps. In fact, most companies and most big organizations, they have complete teams and teams called transitional teams, business transition teams, which look into this to try and synchronize your company. You know, you have to take steps right from creating new business cards or creating new stationery to maybe uniforms for people, to new letterheads, to new branding, etc. All these kind of myriad of things needs to be done to synchronize companies post merger, informing your counterparties, informing, giving taking consents if required, informing your suppliers, your vendors, your customers, changing bank accounts, changing name on bank accounts. These are various things that you need to do. But I think as a first step, even before all this, the final step is getting the people together from the two companies, okay, introducing them to each other and making sure that they gel well and they synchronize with each other. I think, to my mind, is the first step, because that step, if that step happens well, everything else from that can flow nicely and smoothly and happen. But people, it's those people skills and those getting those people together. If people are together, then everything else can flow from it. But if from the first step, if you're not able to synchronize your people together, then the process is not going to be smooth. I think that is it from my end. That was the
Yes,
last two
sir.
questions also. Any other questions
Yes,
can be
sir.
emailed to me and I can get into those. Yeah.
Yes, sir. We are done with the questions. Thank you so much, sir, for the fruitful session, and a special thanks for you for patiently answering all the questions. And I'm sure that they are helpful to all. Now I request our principal, sir, Dr. A.K. Singh, sir, to address the attendees.
Thank you, Maitri.
Thank you, Maitri. Am I audible? Maitri, I'm audible?
Yes, sir. Yes, sir, you are audible.
Yeah, thanks, Mr. Kunal, once again, having interaction with our students second time within short span of 3 months. Though of course it is online, but I think hardly it makes any difference, and this is need of the hour. The TRCL students are very fortunate to have you on the topic merger and acquisition, which is I think the one of the most important topic in the area of corporate law. And I think this is one of the wonderful, one of the best lectures indeed. So on behalf of Thakur Ramnarayan College of Law Management, I thank you once again for sparing your time out of your busy schedule. And once again, thanks and stay safe. Thank you.
You're welcome, sir, and thank you. Thank you for giving me this opportunity.
Indeed, it's a very wonderful and very nice. I think one of the very complicated, complex topic you dealt in a very simple manner and very detailed. I think I'm sure the students of PRCL are blessed with this topic and with your talk.
No, no, you're welcome. Now, it was a pleasure again to speak to all the students of TRCL. I have a small request. I know you're going to be taking a feedback after this. Would be great if that feedback can be sent to me also, so that will really help me in preparing for any future lectures or interactions with all of you.
Yes, sir. We will definitely be sending. And can I have your permission to link with the video to our channel for this lecture?
I'm sorry. Say that again. I didn't hear that.
No, this your lecture, the video we can this thing link to our channel, YouTube channel.
Yes, please do send me that as well. That, and of course, if you have a yes, you can put it up there and send me the link.
Channel. Sure, definitely will do. Definitely.
And if you can, then from the first session also that we conducted in March, if you could send me the feedback from that session, that would be very helpful.
Okay. That we have, sir. We definitely will do that.
Yes.
Hello.
Hi.
It was indeed a very wonderful and interactive session. Thank you so much, sir. On behalf of Thakur Ramnarayan College of Law, I, Devna David, am grateful to have been given this opportunity to thank our resource person for the day, Mr. Kunal Kumbhat, sir. Sir, thank you so much for taking out your valuable time and sharing with us your expertise regarding mergers and acquisitions. I am sure all the participants must have learned a lot. I would like to thank our beloved principal, sir, Dr. A.K. Singh, sir. Thank you so much for sharing with us your words of wisdom. I would like to thank the management team of Thakur Ramnarayan College of Law, Mrs. Priyanka Singh, ma'am, the placement consultant, including the teaching and non-teaching faculty members for conducting such a productive and a fruitful session. Lastly, I would like to thank our webinar team, without whom this webinar wouldn't have been a successful one. Once again, I thank all the participants for joining us. You have been a wonderful audience. Hope to see you all the next time. Thank you and have a great day.
Thank you. Thank you.